As each side has a total of 20 minutes of argument. And with that, why don't we get started with our first case, which is Oliver versus State of Florida.
May it please the court. Good morning. My name is Luke Leroux. I'm here representing Michael Troy Oliver in the appeal before the court. And I would like to reserve 4 minutes, if I may, for rebuttal.
You got it.
Let me start off by giving you a little bit of background about Mr. Oliver. He is a graduate of Clearwater High. He was a member of the Navy, learned how to become an electrician while he was in the Navy, and was working as an electrician when he met Nicole Oliver. He married Miss Oliver. He had already had a son from a prior marriage named Matthew. She already had a daughter named Piper. Piper is the alleged victim in the case, and they had 2 children together, L.O. and C.O. Their marriage broke up in large part because of a lot of disputes they had over monetary issues, one of them being, as we've called in the briefing, the sinkhole issue.
Regarding the monetary issue that you contend, could serve as evidence of motive.
Yes.
What cases do you have that would support a reversal for exclusion of exculpatory evidence that shows a motive not of the victim herself, but of someone else who might have some persuasive power over the victim?
Well, I think the cases that I referred to, and they are in my brief from page 56 on, are the cases that say if that's one of the theories of the defense, then you're allowed to explore that. I don't know that it goes specifically to the motive of the victim as much as the motive of the mother. And you have to understand.
The mother didn't testify, right?
She did, briefly, but I couldn't go beyond the motion and eliminate it.
She didn't present hearsay testimony of what happened, what allegedly happened.
Only briefly. And I think, I'll try to.
The witness testifying to what happened is the victim.
Correct.
And that this evidence doesn't necessarily, or does it, you can make the argument, bear upon her potential bias. It bears upon her mother's potential bias.
It does in the circumstances that I described in the brief. First of all, the issue here between this sinkhole money, the day after this event, the disclosure at the Dairy Queen, when the mother is checking the young lady's cell phone, finds Pornhub, all kind of very graphic sexual depictions on her cell phone. She keeps copious diaries, the mother. And the next...
So is the theory, I mean, we're all...
Sure.
Is the theory, but I was a little confused, is the theory that the mother saw this as a moment of opportunity?
We call it a jackpot.
So, in other words, the theory wasn't going to be that the mother tried everything, but rather the theory wasn't that the mother that elicited the initial report. In other words, the initial report from the child to the mother happened after the mother, according to the theory of defense, discovered pornographic material on the child's electronic device. So the theory must be that the mother saw this as a moment of opportunity, but this is a abuse of discretion standard, and isn't it possible that a reasonable judge could think that's too attenuated?
We respectfully, we submitted that it wasn't because of the circumstances, because if you look at her diary, the very next day she starts talking about, and it's become quite clear to me that Mr. Olive's motive is driven by his greed for money, not only the sinkhole claim, but all of the other items I paid off. And this is the day after the disclosure at the Dairy Queen. She goes on to say that, and this is all in her diary, she says that her telling Piper, I told her that she would have to tell her story with lots of good details to another really nice policeman.
How is all that relevant to the statements by the daughter here that all of this happened? I mean, these events took place, some, 5 years prior to when the disclosure was made about the events here with Mr. Oliver.
In that general area, yes.
Okay. And so I know you're making this all about the mother, but how do those come into the daughter's motive to lie at the time? Like what knowledge does the daughter have about all of that information, including the diary?
Because throughout the relationship, when the weekly visitation was taking place, Mr. Oliver had a woman by the name of Stephanie that he married and moved in, and she would lie to the kids because he didn't want them to think that they were sleeping together or anything like that. So she would say she was leaving, but she's actually staying to help him take care of the 4 kids. Throughout that period, Piper was being paid by her mother to spy on them and actually conceded that. And that was something that we got out of her. So we have this sort of circumstance where Piper has consistently taken a position against Michael at the behest of her mother, even getting paid and rewarded to spy on them. So that now that we have this disclosure, and I think it came out that.
Can you give me a timing between those events and the Dairy Queen event?
Those would have been, she stopped visitation at the age of 14.
And she
So-
was how, at the time of the Dairy Queen?
16. So this would have been 2 years after she stopped the visitation.
2 years after all of that. I just don't know that that's relevant.
Well, you know, in the grand scheme of things, I understand that there is that break in time, but because it popped right up, the minute this happened, all of these other issues came to bear, as noted in her own diary, with the messages that she intended, and we use the term coach, to help a child describe with very specific details and all the rest of that. We felt that that was certainly something that would allow us to explore that, because there was threats, and I know that the trial court felt that the statute of limitations had passed on any dispute over the sinkhole claim. It was a substantial amount of money. They fought about it throughout their relationship, and it was the first thing mentioned in conjunction with this tragic exposure that once.
Can you say, first thing mentioned, again, yeah, that was a little confused, you helped me with the record, there was a cover letter, I think, of discovery materials. On that.
The state
Who brought it up first, circa the time of the allegations?
The mother brought up the sinkhole issues first in the same paragraph as trying to establish the desire to coach or help Piper describe in very detailed specifics of what had happened to her. So it just appeared to us that if there's a sincere desire to be concerned for your daughter and having been victimized, as she alleged, and talk about this sinkhole claim in the very first entry in your diary about those issues in conjunction with trying to coach this child, we felt that it was certainly something that we would be able to explore, just as far as the motive and the bias of the mom trying to get Piper to basically do whatever she could to harm Mr. Oliver.
And was there mention of it in her communication to, I guess, was it the law enforcement office? Was that elicited at all, or was that just gratuitous?
No, and that really kind of dovetails into the second aspect of the argument, which is this whole, the failure to videotape. If you'd like me
What I
to.
meant was the mother's cover letter. Is that the correct term to use to describe what the record?
The record was her diary that she presented to the state to assist them. And I think, and I'm quoting from the same diary entry, trying super hard to give good tales about it, like if he just touched her outside or if he put his fingers in it, that she would be able to, quote, trip him up if he did something wrong. So the mother was very active in trying to pursue Mr. Oliver in a very different kind of way from our perspective, more than just trying to seek his prosecution for what he was alleged to have done, but to try to take action against him in a very vindictive, very driven, very motivated way. And I thought, that certainly should have been something that we would be able to bring in front of the trial, in front of the jury during the trial, and then to try to explain that was a big part of this. We had made every effort to try to show how, once this event took place, the mother took a very active role in trying to reward Piper. She got a puppy the next day. She ended up being rewarded by the group called Bikers Against Child Abuse. We had a deposition that they came, and we got them to say, we actually took one of the depositions of one of the members. They take them on motorcycle rides. They have parties. They have all kinds of different things. So.
Well, you say reward, someone might call that something different, like a puppy being comfort, right?
And without these other indications in the diary, certainly we would agree with that. But it just seemed to be following through on the effort to inspire Piper to do whatever she could do to take the most adverse stance and to engage. And I think that when you look at the information, the original information was filed in July of 2016. And then as time went on, the story became more and more intense. I don't know that there would have been any obstacles to a full disclosure initially. Certainly it worked to prevent any kind of punishment or attention after mom found all of the sexual imagery on her cell phone. Mom was mad at her. She brought up Michael, and now mom's mad at Michael, and Piper gets in no trouble at all for having pornography on her phone when she hasn't been with Michael.
This is the 16-year-old being manipulative, the mother, and the mother taking an opportunistic ability right now to slam her ex and hopefully get rid of all the sinkhole issue with the check.
We thought that Nicole viewed this as a great opportunity to eliminate Michael from any further problems she may have had with him.
Why don't we take this moment to go ahead, let's turn, because I know your first issue was the fundamental due process with the failure for the interviews to be recorded.
Yes, and that's.
I don't want you to miss out.
I don't want to leave. Please bear with me. Give me some extra time for answering the questions. But the primary issue to us really comes down to this. Every law enforcement officer that interviewed Piper had the absolute ability to record that interview. I have multiple citations to the various treatises of the U.S. government. We all know about what's happened with these things. And the issue here is you're dealing with one state statute that has the exact same elements, no matter what county you're in, but the counties differ. And in this instance, the first officer to interview, Detective Schaub or Officer Schaub, who's a trainee at the time, has never done this before.
We're all familiar with the record on this. And
Okay.
so everybody turned off their body cam where they had a phone. They could have recorded it. They didn't. And everybody pretty uniformly testified that was Pasco County's policy for whatever reason. I have a question about how this ties into the due process violation that you ultimately have to kind of hang your argument on in order for it to lead to a reversal. You quoted our court's Powers case for the proposition that there is no difference between failing to preserve evidence and failing to create it. Doesn't that case, though, perhaps undermine your argument insofar as that Powers concluded ultimately there was no due process violation where Pinellas County failed to record a field sobriety test, and the court even remarked, quoted, if we were to require the state in every case in its investigation of a crime to leave no stone unturned and preserve the evidence obtained in a manner satisfactory only to the accused, it would shift the line of fairness between the rights of the accused and the rights of society totally to one side.
I understand. Well, the reason we cite Powers is it really stands for the proposition that if it's really easy to do, which I think we established in this record, it should be done, and it should especially be done in this context. This isn't a DUI. This is a serious charge where this gentleman's got 3 life sentences. Every single one of those officers had the easy ability to record this.
And did you bring that up? Was that brought up to the jury that, hey, these officers could have recorded and didn't?
It was, but I think that's an issue of law more than just arguing to the jury that there might be some confusion.
We need to deal with the law's conclusion, at least our court's conclusion, that failure to record when you're able to, in and of itself, doesn't rise to the level of a due process violation.
We sought to distinguish that issue with a couple of different references in the brief. First of all, the reason this is different is that you're talking about someone in a forensic interview. This isn't just some DUI test. This is somebody being interviewed to see whether or not they've been the victim.
But there's no statute that requires it. In fact, the statute on child hearsay allows it. It doesn't say anything about tape recording. And in fact, in State v. Williams, years ago, it was recognized that there weren't any tape recordings required of child interviews. And is there a case now that requires them to be recorded? Even in our technology that we have today, I don't think there's a recent case that has, unless it's only been in a matter of like a confession or something, a different scenario.
Exactly. And all those are
Certainly-
confessions.
But certainly when there's a deposition, once there's a criminal case in a charge, then there's a videotape required. But I don't see where the law requires videotaping of child interview.
The reason that we
You're
made,
equating that to the destruction of evidence, which I think is really extreme.
but the case law supporters, and I'm on page 46 of my initial brief, no material difference between the destruction of evidence by the state's
Right.
affirmative act or preserving the evidence with a minimum of
But there's
inconvenience.
a difference between Powers, which is a DUI, where they're actually preserving evidence, which is that the person that came out of the car is indeed drunk, right, and under the influence. Here, we're talking about interviews, statements about the crime, not the actual evidence. I mean, not the actual, that they're not able to walk a straight line.
Understood. The stress that we made was that if in fact there is the rule of criminal procedure that requires anyone under 18, their deposition has to be recorded so that the court can find out that there hasn't been any undue influence. And even Ms. Herzek, who was the lead forensic investigator, said, well, every other county I work in, they require it, but Pasco doesn't.
So then isn't this a matter for the legislature? Bearing down and saying that there has to be a requirement and that it's a violation of fundamental due process when it's available and they don't use the technology?
I think in this instance, yes. And the reason I say that is that every treatise, every analysis of this issue has absolutely determined that in these types of cases, that's absolutely critical to be able to ferret out whether or not someone's being coached or whether there's been any questions along those nature.
But in the instances where the destruction of evidence, isn't there have to be some sort of bad faith? And here, it was an actual policy that required that they not record the interview. Doesn't that make a difference here? We don't have law enforcement doing something in bad faith.
From our perspective, that policy is
So you would have had
manifest
them-
bad
You would have
faith.
had them violate their policy.
I
I
apologize.
mean, in order to tape record, each of those law enforcement persons would have had to violate the policy, right?
And let's just put it in this perspective. Yes, that policy was there, but it would almost be like saying, okay, we have a policy now that you can't use the more advanced DNA analysis that the science makes available to us to do our job. You can't,
Mr. Lauro, just to let you know, you're into your rebuttal time. I'll preserve the 4 minutes, answer Judge Smith's question, but I want to preserve your time because we hit you with a lot of questions, but answer Judge Smith's question.
I would respectfully conclude that by saying when the lead person that does the investigation, Ms. Herzek, says that that's the best practice and everything else says it's absolutely critical. And it would have been so easy to do. And instead of doing it, they turned off the equipment when it was so easy to use. We think that that's certainly tantamount to bad faith. That policy in and of itself puts anyone in Pasco County in a different position than any other defendant in any other county in the state that does record it. I'm not familiar with any other county that doesn't record it in any of these situations. I appreciate the privilege. Thank you very much.
Good morning, Your Honors. May it please the Court, Crystal Kachi on behalf of the state. I'd like to start with our discussion about the sinkhole claim because, and I'll make a point of clarification about the timeline in this case. So the allegations were disclosed to the victim's mother in 2014. The victim was 12. And so the controversy such that it was surrounding sinkhole claim was in 2011. So that would have put PO well under 10 years old. I'm not quite sure how cognizant she was of this agita between her stepfather and her mother during these divorce proceedings. And there were times during the proceedings where the trial court did say that it was not in the business of redivorcing the parents. These were typical divorce issues. And at the end of the day, from 2011 to 2016, that's a 5-year period.
But doesn't that analysis by the trial court of erroneous lie the actual theory being advanced? The theory is that this was an ongoing dispute, and there was at least evidence that there was an ongoing dispute, or there's a long ongoing acrimony or animus regarding the failure or the husband, the former husband's desire to have part of the money. So focusing solely on the remoteness analysis, doesn't that remoteness analysis ignore the actual theory of defense?
I don't believe it would have ignored the theory of defense had, let's say, the couple still been living together, because one of the factors that's delineated in State versus Townsend when we are evaluating whether child victim hearsay statements are admissible is the potential for the child to be influenced in some sort of domestic situation. The parents weren't living together.
But I'm not quite sure I follow how that matters. The theory is, in other words, the court said, well, this November 11th date is so long ago, but the theory, it doesn't have anything to do with that date. The theory has to do with whether there's ongoing acrimony that motivated the mother to take advantage of the situation and coach the daughter to falsely accuse the father. So the remoteness argument is a bit stilted in its perception of what theory of defense is.
Well, and I think I'll comment on that by some of the comments that we've had from the panel have to do with the motive of the mother, which is not the focus here in determining admissibility, because it's the motive of the child to fabricate.
True enough, but the mom did testify, albeit briefly, so it's a witness against the defendant. The mother is, she's the mother of the child victim in this case. And the theory of the defense was that kid was getting coached by mom because there was bad blood in this divorce about a money issue. The issues that you're bringing up, remoteness, the fact that, whether or not statute of limitations had run, whether or not there was, really anything to this, the fact that they weren't living together, and the fact that the trial judge commented, I don't want to re-divorce these parties, which I totally get. Couldn't all of that have been handled with a limiting instruction? I mean, this is not a probative value outweighed by an unfair prejudice analysis. This is strictly a relevancy analysis, and in that respect, there's case law that says, look at this in terms of relevancy. If that's the vector that's being decided upon in a judge's discretion, that discretion ought to fall in favor of allowing the testimony if it bears on their theory of defense, even if it's one that seems like kind of a long shot. And what are your thoughts on that?
I suppose that a limiting instruction, could have been beneficial, but I'm not sure I'm in the position to argue otherwise. But I want to also focus on this discussion about the cover note. The cover note, which I presume was submitted in response to discovery, where it's the cover note that corresponds with the mother's journal entry the day after PO disclosed. And so that cover note, I know that the appellant was saying that, well, if she's mentioning this sinkhole claim in the cover note, then it must be in the forefront of her mind, therefore speaking to that theory of defense that she was coaching the child. But really what that cover note indicates is that she was trying to be somewhat proactive, because what she was saying was, listen, I understand that Michael Oliver is going to give some statements. Those statements are going to be recorded. And if he, in his mind, trying to justify why this is all happening and brings up the sinkhole claim, then I have more information to give. So that cover note was not her bringing it up sort of out of nowhere. That was her response.
So she was preempting something she predicted might be a defendant's reaction to being accused.
Right.
Which tends to substantiate that this was on both their minds according to her. So in other words, you're saying that does not, I think I understand your point, that does not necessarily support definitively that she still was concerned about this, that she knew the statute of limitations had run, if that is the correct analysis. But the fact that she was predicting that her ex-husband would be suspicious that this was a pretext, that was based on this money dispute makes it, doesn't it at least cross the threshold of relevance? And you can answer that question if you want, but, what I would like to also get to is this, presuming that we determine the trial court should have found it to have relevance, it is relates in some way to a defense, the defendant's right to bring. What is the danger of misleading or confusing the jury? Because you did argue that, and your brief, the state argued that, you know, and what Judge Lucas pointed out was, you know, well, I'll let you answer that question. Well, how would mislead or confuse the jury?
No, I think it would have confused, to the extent that it would mislead or confuse the jury. I think that the state's argument there is that if we were to expound on this sinkhole claim and talk about the relationship between Michael and Nicole, that would have presumably become an improper feature of trial. This would have.
Is that how the analysis goes? That the exclusion of exculpatory evidence that's relevant can be based on the possibility that it could become a feature at trial before you even let any of it in?
Well, I don't think that that's the general rule. I think that speaking for this case in particular and the facts of this case, that again, you know, appellant is saying that we need to have at least some sort of discussion about whatever the motive is of the mother. And so in order to get to the motive of the mother, we have to unpack this story between these two people. And that's what the trial court was trying to avoid. And again, talking about redivorcing people, we didn't want to make this a feature and focus it more on the child.
But if it's relevant, whose burden is it to establish that the probative value, if it's relevant, it has probative value, presuming for the sake of discussion that it has probative value, whose burden is it to prove that the probative value is outweighed by potential prejudice? The party seeking its exclusion, or the party who just wants to admit relevant evidence that supports their case?
No, it would be the party who wants to admit relevant evidence.
Does the party that wants to admit relevant evidence has the burden of excluding a theory of its potential prejudice?
Say that
Does the party seeking to exclude relevant evidence have the burden to establish what the actual prejudice would be, the confusion of the jury? Is it the state's burden to formulate a theory of why the jury would be confused or misled?
Yes, and to refer back to my answer, that would, the reason why any kind of probative value doesn't, I'm sorry, there really wasn't enough probative value to guarantee that the jury wouldn't be misled because of the attenuation. Now, I'm not sure I'm in a position to get you more comfortable on that topic, but that's where we are. That was the state's argument, that if not only was the time from 2011 to 2016 way too attenuated, but the state was just trying to prevent this from becoming a focus on the parents and not the child.
Can I ask about the issue number one?
Sure.
The interviews not being recorded. The defendant focused on an argument on due process violation, but he also did mention the statute and the criteria that the court needed to resolve or needed to apply. Is it possible that under these circumstances, even if it's not a categorical due process violation for law enforcement to have switched off their body cameras, could it be conspicuous enough under the circumstances of the case, perhaps this one, that it actually indicates a lack of trustworthiness? The circumstances by which the statement was reported indicates a lack of untrustworthiness. If in every instance, every law enforcement officer turns his or her body camera off before talking to the child, or alternatively in 23A1, whether there were not sufficient safeguards or reliability because of this suspicion of law enforcement officers turning off their body cameras. And so could it be an abuse of discretion to have admitted it?
Let me make sure I understand your question. So if I paraphrase your question, are you asking, so is it indeed a best practice to have these,
No, I think that would be more like a categorical argument that was on, in other words, the categorical argument is best practices, so it's a due process violation for a jurisdiction just not to let its investigators record interviews with minors. But on a case-by-case basis, 90.803, 23A requires a determination of whether the circumstances by which the statement is reported lack trustworthiness. Isn't it possible that under some circumstances, a systemic turning off of the body camera could undermine the trustworthiness of the circumstances of obtaining this child's testimony?
perhaps, but, I think that even if those statements weren't video recorded, and I'll weave in a conversation about powers on this issue, is that we're not talking about just the flat out failure to preserve evidence. We're talking, the issue in powers, and that's the issue here in this case, is it's a failure to preserve evidence in the way that the defendant wanted it to be preserved. And so even though those statements weren't recorded, there's nothing in the record to say that the appellant or the defendant appellant was prohibited from cross-examining PO, the child victim PO, the child protective team, forensic interviewer, the detectives, to challenge the veracity of those statements that PO told them. So simply because these statements weren't video recorded is not tantamount to those statements not being recorded at all, such that what was reported could be challenged on cross-examination by the appellant. So, we did mention, this is, I think it was Judge Smith who was talking about, isn't this, if we're going to talk about these extrajudicial policies of not recording statements, this is in the purview of the legislature, because we are not here and it's not in this court's purview to comment on or issue an advisory opinion about why Pasco County should or shouldn't be recording statements. It's not in this court's purview to amend Chapter 39 to make it align with Rule 3.220, and it's not in this court's purview to amend the juvenile rules to align with 3.220. So because this court in 1990 has already issued an opinion about a due process violation, we would encourage this, court to really not give more attention to that issue and understand that the issue really is whether the trial court was in error, excuse me, when it made an admissibility determination of the child victim's statements, and that is under an abuse of discretion standard. So if there are no further questions, the state would rely on its briefing for remaining arguments and ask this court to affirm. Thank you.
Thank you. Really, you have your full 4 minutes.
Sure, let me just make this entirely clear. The minute that my client became aware of these issues, his position was that this was created to put an end to his effort to get the quote sinkhole money. That was the first explanation that popped into his mind. It's the first entry in the diary. So mom, literally the day after keeping her diary and mentioning how she's going to coach the child to specifically describe what happened, and using,
That might be a liberal stint. She does not say, I am going to coach my child in her diary.
I'll let the record speak for itself, but there is certainly, I will help her explain with great specificity, things like that. Things that seem, I'm going to let her tell her story would be one thing. I'm going to assist her in explaining is a little bit different than that. But I think, to put this in a complete perspective that I think needs to be addressed is that the motion in limine was given to us the morning of the first day of trial. It was you've got to think on your feet. That's what we do. I'm not going to complain about that, but that was a huge component of the theory of our defense, was that this was part of this whole spying thing, that there was this whole circumstantial area that there was a motive to do harm to Mr.
I don't know if
Oliver.
it's a square peg and round hole, but isn't it possible there's an inference stacking problem for your theory, though? I mean, you have to infer, you have to stack some inferences, John. I mean, one of the inferences is and perhaps I'm wrong, maybe it's not stacking inferences, but that the child's initial accusation was a pretext, or was a something that dissembling in order to get her mom off her back from porn on her device. And then the next one is that, well, the mother, you have to infer that, then the mother capitalized on that. Maybe that's not stacking inferences, but it does go to the trial court's determination of relevance, at least, that it's so attenuated that it's not relevant. Because there's so many steps involved to get to your theory.
There are really only two steps, though. It's the child wanting to get out of trouble and the mother seeing that as a way to keep this man away from the money and out of her life. From us, it was a very basic formula. The equation was quite simple. And quite motive and bias, certainly if it's part of the theory of your case, we thought, we should be allowed to explore that.
Can I ask a quick question real quick? So about, we didn't touch on it, but the questioning of the brother, the half-brother.
Matthew, yes, I'm glad, I'm
Yeah,
so
I
glad.
want to ask a question about that. He took the stand again after the comments made by the trial court outside the hearing, but he never recanted, I don't want to be confusing here, he never recanted his essentially recantation of the prior testimony. He didn't come on and change his tune and say, you know what, you're right, Judge, I wasn't coerced before, I don't want to go to jail for perjury. He held his ground. So the jury heard everything the defendant would have wanted them to hear. They wanted them to hear that he recanted the inculpatory prior testimony.
Let me clarify that, and you had to be there. So the minute he starts to clear it up, you have to understand the background was the grandparents took him in and convinced him that they wanted to have him do whatever he could. He was a minor when his deposition was taken, and he never really said anything specific, but it was as damaging as he thought he could get away with. I took his deposition. While he was in jail, and during the period of time he was on the state's witness list, he sent his dad a letter that says, Dad, I'm sorry, I want to clear the record, I want to make sure that I do it. The state took him off the witness list, and we talked to him, and he said, I got a lot of pressure from the grandparents. They were taking the money that I was getting, all kinds of different things came in. And when he's on the stand, the state jumps up and starts using the word perjury. Now, mind you, there's a lot of case law that says just using the word perjury is not a big deal, but what the court did after that, and I think I even wrote down a note to that effect, but
saying, hey kid,
just,
you know,
and I mean,
watch out.
took the jury out for a long time, called his attorney, and when he went back on the stand, he'd been crying for 20 minutes. It was a complete and total
But it didn't change
interruption.
his testimony.
Pardon me?
The threat of perjury didn't change his testimony.
It didn't change his testimony, but that break in the action,
You'll need to answer Judge Atkinson's question, but you'll need to wrap up. I'll let you go a little long again.
I think the whole concept is being able to fairly use a material witness effectively. I don't know that anything he said at that point was effective. I think there had been so long of an interruption, he'd been so rattled, and even if it was consistent, it wasn't the same. It wasn't what he would have been able to present had he not been interrupted and threatened the way he had. I'm very grateful for your time and consideration. Thank you for the privilege and have a good day. Thank you.
Thank you all.